students to part 9 of Constitution. We are going to study about Constitution further. Classification of Indian Constitution. The term Constitution is derived from the Latin constitute, which means to establish. The Constitution is a basic document of a state. It is the fundamental rule of a state which regulates the distribution of powers within organizations of government. The supreme law of the state. It is the foundation and source of the legal authority underlying the existence of the state. It provides the framework for the organization of the state government. A constitution is a basic design which deals with the structure, power of the government. It also includes the rights and duties of the citizens. Sometimes it is found in an established body of rules, maxims, traditions, practices in accordance with which its government is organized and its powers are exercised. Written and unwritten constitution. A written constitution is a formal document defining the nature of the constitutional settlement and the rules that govern the political system and the rights of the citizens and the governments in a codified form. So, a written constitution is normally supposed to mean a document or a collection of documents in which the basic rules regarding the main organs and institutions of the governments are clearly laid down. Example, the Constitution of India was formulated and adopted by the Constituent Assembly. An unwritten constitution reflects the evolutionary nature of the free documentation of the rules and regulations. First they are practiced, and by a continuous practice they become a part of the construction. The Constitution of Britain is the best example of an uncodified constitution. It's a type of constitution where the fundamental rules often take the form of the customs, usage and precedents and a variety of the status and the legal instruments. A new condition and situations of government may be resolved by precedent or passing legislation. Flexible and rigid constitution. The classification of the constitution should be based on the method of amendment to the constitution. In a flexible constitution, there is no distinction between the ordinary law and constitutional law. Both are enacted in the same way and the source is also same. Constitution may be written or largely based on conventions. These are the rules or the lines of the regulations. They are amended in the same way. No special procedure is required for amending the ordinary or constitutional law. The Constitution of Britain is a classic example of a flexible constitution. Parliament in the Britain is sovereign, and in Britain constitutional changes can be made by following the same way as an ordinary law is enacted. The courts have no authority of review. Rigid constitutions are those which require a special procedure for the amendment of the constitution. The constitutions of USA, Australia and Switzerland are the examples of rigid constitution wherein the change or flexibility is nominal or equal to no. The rigid constitution is above the ordinary law and can be changed by the procedure only by the law, which is different from the procedure of ordinary law, thus making it difficult to change. The objective is to emphasize that the constitutional laws embodies the will of the sovereign and it should be treated as a sacred document. American Constitution is the best example of a rigid constitution. The American Congress cannot make any of the law contrary to the Constitution. The American Supreme Courts act as the guardian of the Constitution and it has the right to declare any law of Congress null and void. Constitution of India is neither so flexible as the British Constitution nor so rigid as the American Constitution, but it is a midway, which means more rigid than British constitutions and less rigid than others. Unitary and Federal Constitution. A unitary state is a state governed as a single power in which the central government is ultimately supreme, and any administration, divisions, subnational units exercise only powers that central government chooses to delegate. The majority of the states in the world have a unitary system of government. A unitary system is governed constitutionally as one of the single unit with one constitutionally created legislature. This means that all the power of the government are centralized in a one government and that is central government. The most famous example of unitary constitution is UK. In unitary constitution, the provinces are subordinate to the center. A federal constitution is the one which sets up a system of federalism within a country. Federalism is a political system in which the national government and a smaller government states or provinces each have their own powers that are specified by the constitution. In such a system, neither the level of the government has the ability to infringe on the rights of the other levels of government. US Constitution, which gives specific rights and powers to the state government and other rights and powers to the national government. Quasi-federal constitution. It combines the features of a federal government and the features of a unitary government, which can also be called the non-federal feature. Because of this, India is regarded as a semi-federal state or a quasi-federal state. The Supreme Court of India also describes it as a federal structure with a strong bias towards the center. So we have both the quasi-governance of both center and the state. So that's all for today, students. Please do write down the notes. Thank you. We'll be taking next session in the next class.